Williamson Chang.
Good afternoon, board. My name is Williamson Chang. I'm a professor of law at the University of Hawaii and have been for 39 years. That's the longest serving member of the faculty. I am here as the counsel for Mr. Hanalei Fergustrum and Mr. Ioane, who are filing a request for a contested case hearing. And that was filed at 7 o'clock this morning, but now I realize the rule has changed. So I'd like to take care of that by filing a new request. And I don't have much time up here. If you want to know what I'm going to argue, you can read the testimony I have filed, and I have extra copies here if you haven't seen it. They're available here. And I have copies for all of those who are outside as well. I always try to bring them. First, I want to say that in filing the contested case hearing, it occurred to me that what's not going to happen, which usually happens, is there's going to be a stay on the administrative action. There's no question that the trucks that are building the TMT are going to continue up under this rule. This rule is a pretty thinly disguised effort to facilitate what the governor said. Essentially, the TMT is going to be built. And that bothers me. I don't think that the 120 days of truce and negotiation can take place in such an environment. And if this board either doesn't grant the contested case hearing or doesn't stay the effectiveness of the rule, essentially I'm going to be forced to move to court to enjoin and declare the actions of this board in adopting C1 and C2 to be unconstitutional, beyond your powers under state law, beyond your powers in Section 183D, and I know you had an hour with the Attorney General. I'm going to be across from him. I only have 32 seconds left. So if you want to ask me what my strategy is, I'd be happy to answer that. But first, let me say, I'm probably going to have to name you as individual defendants in your individual capacity. That's just required by law, and it's nothing personal. I am admirers of all of you, and I respect you, but this will be decided in the courts. Thank you.
Thank you.
Madam Chair, I have a couple of questions.
Okay.
Professor Chang, you wrote an article in Civil Beat where you said a number of things, but one of them was that President Obama could stop the construction on Mauna Kea by invoking the Antiquities Act and declaring it a national monument. That's completely wrong, you know.
It is wrong. I apologize. What I meant was you could start a process by which eventually it could reach the status of a World Heritage Site, which was a pretty fast track for Mauna Kea, and then perhaps we could stop it. In other words, I was really just saying one thing, which is we have a local boy as president, and this is a really important issue to the state in which he was born, and he ought to weigh in some way, either mediate or do what he thinks is best. And I think it's funny that Mauna Kea is simply a conservation district area, whereas Mauna Loa and Kilauea are on the World Heritage Site, and Mauna Kea is a World Heritage Site, and they're married together.
You basically, I had this question about the legality of using the Antiquities Act, and you answered that question. I also have a question. Basically, you provide us a 30 or 40 page legal brief which I take it as arguing that the United States government has no authority.
No, I argue that BLNR has
No authority. Because the United States government had no authority?
no, because if you look in the state constitution, the territorial boundaries define what's in the state as all the islands that are acquired by the joint resolution.
Yes.
And do you believe, sir, that a joint resolution of Congress of the United States could acquire a foreign sovereign independent country?
I'm not here to debate that point. I just
Well, that's the definition of the territorial right.
The question I was going to ask you is, do you think there is federal authority, U.S. federal authority over Hawaii?
Yes, they're clearly here.
Thank you.
Thank you. All right, our next